They thought I was losing my mind. Maybe I let them think that. I am 67 years old. I built a furniture business with my bare hands over 4 decades. The kind of work where you feel every joint at the end of the day, where sawdust gets into your lungs and your dreams, where you measure a man not by what he says but by what he makes. My wife, Margaret, stood beside me for 39 years. She passed 18 months ago, quietly, in the bedroom we shared. On a Tuesday morning when the light came in sideways through the curtains and made everything look gold, I held her hand until it went still. I thought the worst thing that could ever happen to me had already happened. I was wrong. It started small, the way these things always do. My son began calling more often. Not to check on me, I understood that later, but to take inventory. He would walk through the house when he visited, fingers trailing along the edge of the mahogany dining table I built in 1998, pausing at the workshop door, counting. I noticed, but said nothing. I am a quiet man. I have always been a quiet man. Margaret used to say I kept too much inside. She was right about most things. My son is 41. He married a woman I will call my daughter-in-law, because that is what she is, legally. Though the word has come to feel hollow. She has a way of smiling that never quite reaches her eyes. She smiled that way at Margaret's funeral. She smiled that way when she suggested, 6 months after my wife was in the ground, that perhaps I should think about simplifying. I asked what she meant. She meant the house. She meant the workshop. She meant the 63 acres of land my father passed to me, and I had spent a lifetime tending. She used words like burden and upkeep. And at your age, my son stood beside her and nodded the way he always did when she spoke, like a man who has forgotten he has his own neck. I told them I was fine. They smiled. Both of them. That smile. 3 weeks later, my son called and asked if I had forgotten his birthday dinner. I had not forgotten. The dinner was the following Saturday. He said it was last Saturday. I checked my phone, my calendar, the paper calendar Margaret kept on the refrigerator that I still updated in her handwriting style because it made the kitchen feel less empty. The dinner was the following Saturday. I told him so. There was a pause on the line. Dad, he said, are you sure you're okay? I said I was sure. I was not yet worried. I should have been. The next thing was the pharmacy. My daughter-in-law called the pharmacist, I found out later, and expressed concern that I had been picking up medications irregularly. She presented herself as a caring family member, trying to coordinate my care. The pharmacist, understandably, noted my record. My son had a copy within the week. I did not know this yet. I was still building a rocking chair in my workshop, listening to Merle Haggard, drinking black coffee, living my life. Then came the doctor. My son asked me to see his physician for a routine checkup. I had my own doctor of 20 years, but my son said his was newer, better, had more updated equipment. I went because I had nothing to hide and because I was trying to be cooperative with my grief-stricken child who had just lost his mother. The appointment lasted 45 minutes. The doctor was young, polished, and asked me a series of questions that I later recognized as a cognitive assessment. Who is the president? Count backward from 100 by sevens. Draw a clock face. I answered everything correctly. I drew the clock. He told me I was in excellent health for my age. What he did not tell me, what I found out 4 months later, was that my son had requested a written summary of the appointment and had received one. Nor did he tell me that my daughter-in-law had spoken to him privately in the parking lot before I arrived. I know this because I installed a dash cam in my truck 6 weeks after that appointment. Not because I was suspicious yet, because my grandson had asked for one for Christmas, and I bought 2 by mistake and had 1 left over. That is the honest truth. The camera sat in my glove compartment for 2 weeks before I mounted it, and even then, I only turned it on because I liked watching the road roll by when I reviewed footage on quiet evenings. I am a man who notices things. 40 years of fine woodworking will do that. You learn to see the grain, to spot the imperfection before the chisel finds it. So, when my daughter-in-law's car was parked outside my attorney's office on a Thursday afternoon, when she had no reason to be anywhere near that part of town, I noticed. My attorney, Howard, had handled my affairs for 15 years. He was the man who drew up Margaret's will, who structured my business trust, who knew every asset I had down to the last acre. He was also, as I discovered when I called his office the following morning, no longer available to take my calls. His assistant said he had a conflict of interest. I sat with that for a long time, a very long time. Then I called my accountant. Same thing. A conflict of interest. Regrettably unable to continue our professional relationship. So sorry for any inconvenience. I put the phone down and looked out the kitchen window at the oak tree Margaret planted the year our son was born. It was November. The leaves were gone. The branches looked like black cracks in a gray sky. I thought, they are moving all the pieces. I thought, I have been asleep. I was not angry yet. I drove to the county courthouse that afternoon and pulled the public filings. It took me 20 minutes. My son and daughter-in-law had filed a petition for guardianship. They were seeking to have me declared legally incapacitated, cognitively impaired, unable to manage my own financial and personal affairs. They had a doctor's statement. They had pharmacy records showing inconsistent medication use. They had 2 signed affidavits from neighbors I had known for 30 years. Neighbors, I now understood, had been visited and coached. The hearing was set for 8 weeks out. I sat in my truck in the courthouse parking lot for a while. The engine ticked as it cooled. A woman walked by with a stroller. A cloud passed over the sun. I thought about Margaret. I thought about what she would say. She would say, "Don't get loud. Get smart." So I got smart. The first thing I did was drive 4 counties over and hire a new attorney. Her name does not matter. What matters is that she was sharp, thorough, and had spent 20 years fighting exactly this kind of case, what she called predatory guardianship. She told me it was more common than people realized, particularly with widowed men and women of property in their 60s and 70s. Children, she said, sometimes stopped seeing a parent and started seeing an inheritance. I told her everything. She listened without interrupting, which I respected. When I finished, she leaned back in her chair and said, "Do they know you know?" "No," I said. She nodded slowly. "Good. Keep it that way. Good. 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 Keep it that way." Over the next 7 weeks, I did not change my behavior. I called my son on Sundays. As usual, I sent my daughter-in-law a birthday card. I attended church. I went to the diner on Route 9 every Tuesday morning and had eggs and toast with my old friend Gerald, who is 72 and as sharp as a finishing nail, and who agreed, when I explained the situation, to document everything he had ever observed of my mental clarity over the past decade. Gerald had kept a journal since 1987. The man was a gift. My attorney subpoenaed my actual medical records, not the summary my son had requested, but the complete files from my doctor of 20 years. Dr. Whitmore had seen me through Margaret's illness and death, through my own bout with pneumonia in 2021, through the ordinary deteriorations and recoveries of a man in his late 60s. His records showed a man of above-average cognitive function, no signs of dementia or impairment, a patient who asked detailed questions and remembered the answers at follow-up appointments. We obtained the full cognitive assessment from my son's doctor. My attorney reviewed it with a specialist she trusted. The specialist noted that the assessment had been scored selectively, several correct answers had been marked ambiguous, and the written summary used language that implied confusion I had not actually demonstrated. This specialist agreed to testify. We also hired a private investigator. I want to be clear that I did not enjoy this. I am not a man who operates in shadows, but I had been given no choice. And so I paid for 2 weeks of surveillance on my son and daughter-in-law. And what came back confirmed what I had begun to suspect in the worst part of my gut. My daughter-in-law had been in contact with a real estate developer. Not once, repeatedly. Over several months. The same developer had, 6 weeks after Margaret died, submitted an informal inquiry to the county assessor's office regarding the rezoning potential of my 63 acres. The timeline fit perfectly against the timeline of the guardianship petition. If I were declared incapacitated, my son would be appointed guardian. As guardian, he could manage my assets in my interest. And managing my assets in my interest would look, apparently, a great deal like selling my land to a developer for a price that would make my daughter-in-law smile with her whole face for once. My attorney was quiet for a moment when I laid all of this out. Then she said, "We're not just going to defeat this petition. We're going to bury it." The morning of the hearing, I dressed deliberately. Dark suit. The one I wore to Margaret's funeral and had dry cleaned since. White shirt. The tie she gave me for our 35th anniversary, burgundy. Simple. I was not going to walk into that courtroom looking like what they wanted me to look like. I arrived early. I sat in the hall outside the courtroom and drank coffee from a thermos and read a chapter of a novel Margaret had bookmarked before she died. I had been reading it slowly, one chapter at a time, trying to make it last. My son and daughter-in-law arrived 20 minutes later with their attorney, a man I did not recognize. My son saw me from across the hall. He paused. I think he expected something different, something more disheveled, more confused. I nodded at him. He nodded back. His wife looked at me for a moment longer, and then looked away. They went inside. I finished my coffee and followed. The courtroom was smaller than I expected. The judge was a woman of perhaps 55, with reading glasses on a chain and the expression of someone who had heard every variety of human foolishness and remained unimpressed. I liked her immediately. The petitioners went first. Their attorney was competent and organized. He presented the doctor's assessment, the pharmacy records, the neighbor affidavits. He spoke in measured tones about concern for my welfare, about the challenges of aging, about the responsibilities of family. My son sat with his hands folded on the table, performing sorrow. My daughter-in-law sat beside him performing grief. They were good at it. I will give them that. Their attorney painted a picture of a confused, forgetful old man rattling around a too large house, making poor decisions, at risk of being taken advantage of. He did not say by whom. He did not need to. The implication was that the world was full of predators, and my son was a concerned and loving barrier against them. At one point, my daughter-in-law reached over and touched my son's hand. The judge watched this. Then it was our turn. My attorney did not rush. She is the kind of person who understands that patience is its own form of power. She began with Dr. Whitmore, who testified via prepared statement, thorough, clinical, unambiguous. 20 years of records, no cognitive decline, a patient of exceptional attentiveness and communicative precision. The opposing attorney tried to diminish this as outdated, as potentially biased by a long personal relationship. My attorney let him finish. Then she introduced the specialist's review of the cognitive assessment, the selective scoring, the manipulated language in the written summary. The opposing attorney objected several times. The judge sustained very few of them. Then Gerald took the stand in person. 72 years old, retired engineer, straight-backed and clear-eyed, with 30 years of observations and a journal that cross-reference dates the way only an engineer's journal can. He was not a dramatic witness. He was better than dramatic. He was precise. The opposing attorney asked Gerald if he was a medical professional. Gerald said no. He was an engineer. The attorney suggested Gerald was therefore unqualified to assess cognitive function. Gerald said he was qualified to assess whether a man could accurately recall conversations, honor commitments, demonstrate logical reasoning, and engage with complex problems over time, and that in 30 years of Tuesday morning breakfasts, I had never once failed to do any of those things. The judge made a note. Then my attorney asked the judge for permission to introduce a supplemental exhibit. The opposing attorney rose immediately, objecting that no such exhibit had been disclosed. My attorney noted calmly that it had been filed with the clerk at 7:15 that morning, well within the procedural window, and she had the timestamp. The judge reviewed the filing log on her tablet. She allowed it. My attorney handed the judge a sealed folder. Inside that folder was a documented timeline, the real estate developer's inquiry to the county assessor. phone records showing 47 communications between my daughter-in-law and the developer's office between April and November of the prior year. A formal development proposal, the kind prepared speculatively before a deal is closed, to show investors the potential value that referenced my property by parcel number. Emails my son's own attorney had sent to the developer's counsel, discussing anticipated asset availability following the guardianship resolution. They had been so confident. That is the thing I keep coming back to. They had been so certain that I was exactly what they said. I was a diminished, confused old man who wouldn't notice, who couldn't fight back, who would sign whatever was placed in front of him and drift through the remainder of his life, not quite understanding what had happened. They had forgotten who raised my son. They had forgotten who built everything they were trying to take. The judge read the folder. She read it thoroughly. She did not rush. The courtroom was quiet in that particular way. That courtrooms get quiet when something important is shifting, when everyone in the room senses that the ground is moving under certain feet. My son was no longer performing sorrow. He was staring at the table. My daughter-in-law had stopped touching his hand. The judge set the folder down and looked over her reading glasses. She did not burst out laughing. That is a story for other people. What she did was something more satisfying. She looked at my son's attorney and asked him, in a voice that had no warmth in it at all, whether he wished to reconsider his client's position before she entered findings. My son's attorney asked for a brief recess. The judge said no. The petition was denied. Not dismissed, without prejudice denied, meaning they could not refile without substantially new grounds. The judge added language to her ruling that I did not anticipate. She noted that the evidence presented suggested the petition had been brought not in good faith, concern for my welfare, but in furtherance of a financial scheme, and she was referring the matter to the State Attorney General's office for a review of potential elder financial abuse under the statute. She said this in the same flat, even tone she had used for everything else. It landed differently, though. I watched it land on my son's face. My attorney touched my arm briefly as we stood. Just briefly. We walked out into the hallway, and I stood for a moment by the window that looked out over the parking lot and the bare November trees beyond it, and I breathed. Just breathed. My son came out several minutes later. His wife stayed inside. His attorney had already left through a different door. He stood about 10 feet from me and looked at the floor and then looked at me. And I could see that he was trying to locate something, words, or maybe a version of events that made him less than what he was. I did not make it easy for him. But I also did not close the door completely. He is still my son. But that is the complicated truth that I have turned over many times in the months since. The way you turn over a piece of wood, looking for the grain, trying to understand what you're working with. He is still the boy I taught to ride a bike on the gravel driveway. He is still the person who stood next to me at his mother's grave. What he did came from somewhere from her. Probably. From years of being reshaped by someone whose smile never reached her eyes. I am not a saint. I told him I was not interested in speaking with him until he had spoken with someone who could help him understand what he had participated in and why. I told him the door was not locked, but I was not going to stand there holding it open. Then I walked to my truck. The following spring, the Attorney General's office completed its review and referred the matter for prosecution. My daughter-in-law's attorney negotiated a settlement that involved, among other things, full financial restitution for my legal costs and a formal acknowledgement that no cognitive impairment had ever existed. My son was not charged, having cooperated with investigators, but he was named in the civil findings. The developer's proposal was withdrawn. My 63 acres are still mine. I finished the rocking chair I had been building during all of this. Walnut, with steam-bent backslats and hand-cut joints. I put it on the porch where Margaret used to sit in the evenings, where she could watch the light go down over the back field. I sit there now sometimes and drink my coffee and think about what she would make of all of it. I think she would say I took too long to notice. I think she would also say, but you did notice, and you did what needed doing. I am 67 years old. I built everything I have with my hands, and I kept it with my eyes open. I was quiet for a long time, and people mistook my quiet for weakness. which is a mistake that tends to be self-correcting. If anyone is watching this who is in a similar position, who feels something shifting around you, who senses that the people closest to you are suddenly very interested in what you own, I want to tell you something. You are not imagining it. Your instincts are good. Get a notebook. Get an attorney from outside your immediate circle. And do not let anyone convince you that your own clear mind is the problem. The problem is never your mind. The problem is always the people who benefit from convincing you that it is. My name is not important. What I built is important. What I kept is important. And the quiet way I won on a gray November morning, in a small courtroom, while my son stared at a table and the truth sat in a folder in a judge's hands, that is the part I will carry with me for whatever years I have left. Margaret would have liked that judge. I think she would have liked her very much.